Oops. Alright, 3, 2, 1. This is hearing number 3, where I was told that my request for police policies was too vague. So here's the back and forth. I'm only going to read Briggs and Judge and Owsley's words. I'm not going to read mine. And this doesn't involve Cloyd Benjamin. They brought in other attorneys for this one. Alright. Judge, City of Natchitoches versus Travis Hines. Sir, are you here on this matter? Yes, Your Honor. We're here on the motion to quash. Certainly, come forward. Your motion's first, so we'll wait until Mr. Benjamin is in the courtroom. Alright. Mr. Benjamin's not in the courtroom, but this is your motion. You're here on behalf of Gold Weems. Is that right? Yes, Your Honor. We're here on behalf of the City of Natchitoches. And what is your name, sir? My name is Morgan Briggs. I believe you signed the petition or the motion. The motion, yes, Your Honor. Today, we have 3 motions set before us. The first is filed by your office, sir. That's the motion to quash the subpoena duces tecum. The second is a motion for Mr. Hines in limine to suppress certain evidence. The third is a motion to suppress witness statements. I'm going to handle the first one first, and then Mr. Benjamin and Mr. Hines, you can argue over the second one. So it's your motion, sir. Go ahead. Real briefly, Judge, the subpoena duces tecum that was issued requested 3 things. It requested police policies, it requested specific training information of certain police officer, and then it requested certain disciplinary records of certain police officers. If I could work backwards through those, can I interrupt you for 1 second? Yes, sir. It's my standing motion, as I have always said. If I have to make it clear every time, is that there will be no recording, video or audio in this courtroom. Go ahead. Understood. The request for disciplinary records. Louisiana courts have already ruled that individual employees have a reasonable expectation of privacy in their disciplinary records. We cited that case. It's the East Bank versus Crossen, a very similar case. In that case, the court held that fire officers had a reasonable expectation of privacy in their disciplinary records, and it was not subject to production. Similarly, Louisiana revised statute 44.3 provides that certain information is also exempt from production. It includes in that list security information and training information. Louisiana's Attorney General has already issued an opinion which we cited, saying that training information of officers that do training is protected from disclosure under the statute, so it can't be disclosed. And third and finally, there's a request for police policies. We're not exactly sure which police policies, so we can't respond in specific as to which policies were requested. However, under that same statute that we talked about, Louisiana revised statute 44.3, the Attorney General has also said that certain police policies are exempt from disclosure under that same prohibition of training techniques, aids, and security information. Unlike anything like that is not subject to production under 44.3. Alright, Mr. Hines. Now you had actually submitted, I believe, a response. Okay, and then I go into all kinds of arguing against what they said. Well, I already pre-planned what I was going to say. Sir, your response? Yes, Your Honor. Just real briefly, Mr. Hines raises an objection that the city produced a blanket denial to police procedures. That's correct. That's because the subpoena was a blanket request. It didn't ask for specific provisions. If Mr. Hines would have asked for specific provisions, we could then review those and we could attempt to conduct a balancing test with the custodian. And if we are still unable to reach an agreement there, then that is right for the court to conduct a balancing test to determine what interests apply. But since we're here today just on a blanket request, we submit that it should be denied. Now, what does the document that the court provided you the other day that was left with our office? I did not look at those envelopes. Does that resolve any of your motion at all? The training records help, yes. Okay, so you did receive some records from the police policy, city police office, yes. Certificates, yes. Okay, well, my concern here, number one, is the subpoena is vague. There's no doubt about that. I don't think you can just ask for police policies and they know what to give you. The other concern I have here is discovery in this case is limited to this case. I think you waver between a civil rights action, which is your right to file, but this is not the court to hear it in. It's beyond my jurisdiction. Second, it's a federal action, so I don't believe this is a 1983 action. You certainly can bring that if you choose, but I think that's where you would be looking into that kind of discovery. I think regarding this, they made an effort to respond. They have provided you with some training. They could have given you a blanket denial, but apparently the city police have turned in some bonds, and they have provided you with some training. They could have given you a blanket denial, but apparently the city police have turned in some responses to this. So I'm going to grant their motion to quash the subpoena duces tecum, in part in that you have been provided some information. Otherwise, I think your request is vague. I also do believe that some of this is protected under Louisiana Revised Statute 44.3. Finally, I don't know how relevant it is. And my concern is the question in this case is whether or not there was a crime committed and that you had a right to be arrested. The training of the officers, in my opinion, is not relevant to that. I think whether your actions are relevant, whether they had reasonable suspicion and acted on that is relevant. But I don't think whether they were trained properly has ever been relevant in this matter. But again, that could be under a different action, under a civil rights action, if that's what you're doing. I'm not going to rely on Code of Civil Procedure because you're right, this is a criminal matter. And I'm not going to rely on that, but I am going to rely on the relevance of this issue. So I'm going to quash it. I'm not going to grant a protective order, though, sir, but I will quash the subpoena duces tecum in the part that they have not already provided. You have not already provided that information. All right. Thank you, sir. Thank you, Judge.